Hello friends, hi. This side Naveen. Can you just make a wild guess about how many cases are pending in India? It's whooping 4.7 crore cases, more than two times the population of Delhi. But the good news is that out of 70,000 pending cases in Supreme Court has cleared 6,844 cases in almost just 1 month since the Hon'ble Chief Justice Sh Chandrachud took the charge. It's a rare event which per se looks like it is solving the problem of output versus input. That is, rate of disposal of cases has exceeded the rate of filing of fresh cases, and we have a long way to tackle the problem of pendency of cases. But the problem remain almost same at the district level, where the rate of disposal is quite less when compared to the rate of filing of fresh cases. As the Honorable Chief Justice of India has already stated that India survives much beyond Delhi, and we need to focus on district judiciary as well. As an advocate, I feel one quick way that we can help district judiciary is by relieving the workload of lower court judges. I have seen that lower court judges has to make approximately 200 to 250 signatures every day on various orders, which can be solved by a small twitch or a change, that is by making mandatory use of digital signatures in all orders that needs to be manually signed. You may think that the strength of judges per person may be the culprit of pendency of cases in India, but I feel the biggest problem is the way the adjournment of cases is handled at the lower courts. As long as we have the old gatta system wherein a judge considers the request of both the parties in assigning a new date and cases are adjourned as per the request made by the councils appearing, this way we will never be able to solve the problem of pendency. If the adjournment of dates are manually handled, there should be a timeline for everything, and the case should travel through the software system which is based upon laws and lands, any breach of which may be automatically handled by the computer system, which is given in law as well. For example, in section 125 CRPC, there is a law that the interim order shall be decided within a period of 2 months after the service of notice to the respondent, but it seldom happens. There is a law in a civil case that a written statements need to be filed within 90 days, which also rarely happens. There is a law in a negotiable instrument case or a check bounce case that it has to be decided within 6 months. I have a case which is lingering on for more than 6 years. There is a law that a commercial court case has to be decided within 6 months, but it rarely happens. Not only this, this is a serious thing, that is that there is a law that the rape case, a rape victim evidence has to be recorded within 2 months. It also rarely happens. So my point is fairly simple. I want to say that the use of technology, with the use of technology, we can codify the law, and the breach of it may be automatically handled by the computer system. And as a case travel through the system, it automatically assign whatever a case needs to be, whether a case need a shorter date or a longer date. Honorable Justice D.Y. Chandrachud has already directed to organize a hackathon event in the Supreme Court, which would be a novel event in the history of this court. Do you think it is a novel idea to let the computer system decide about the next date and about the next date to be given in a case, considering the set laws and rules, and make the changes in the current system of signing the dates in the courts and completing completely getting rid of the gutta system? Do comment in the video if you have any suggestions, or if you like the video or you want to add up to this. Thank you so much. This is your friend Advocate Naveen Arya signing off. Jai Hind. Thank you so much.